in semiconductor. Our original moderator was unfortunately unable to make it today, so her shoes are a hard one to fill, but I'll be moderating in her stead. But I have excellent panelists, so I'll give all the airtime to the panelists today. But some of you might have been here for the previous panel. That one was really about, the theoretical and academic discussion about what is going to be happening through free trade. We covered different types of trade tools that are at, the country's disposal for, either controlling or maybe restricting free trade for various purposes. This one is going to be more for, the practical approaches to how you sort of mitigate the risk of all the compliance, different regulations that are happening, how do you follow them, how do you keep track of them, and what do you do with them. So it's going to be really a free-flowing discussion by the panelists about, the different perspectives that they bring. We have an in-house counsel, and then we also have, a Korean lawyer, a US lawyer. They all bring different perspectives of how you deal with that question of when regulations continue to change, how do you comply with it. So we'll sort of try to have a free-flowing discussion, but we'll keep questions to the end of the panel. And please keep in mind that the views of everyone here are their own. It's not attributable to the organizations that we're part of or our clients. And then, so we'll sort of start with introduction of our panelists. So Steve.
Yeah. Hello, my name is Steve Son. My passport name is Sang-Soo Son, but I go by Steve for many years. So especially in the semiconductor industry. Call me either way is okay. I've been with the company for 25 years, same company, which is not rare in Korea. But if I say the same thing in the United States, wow, but the most of the reaction is wow, 25 years. But a little bit like unique experience because I joined, my first company was LG Semiconductor, which is not existing anymore. And then LG Hyundai merged. So it became Hyundai, and they changed the name to Hynix. Now we call it SK Hynix. So I've been through like 3 conglomerates at the same company. I think, the fact that those kind of, 2 major mergers shows, the consolidation in the semiconductor industry. So we're gonna go back to the topic, briefly, but I think the industry has been very dynamic, and so I've been with that kind of company and industry for 25 years. And in the company, very early years, I did lots of trade remedy cases together with some experts sitting here, and also like about last 5-6 years in DC, I'm doing most of my responsibility. Has been export control and sanctions and compliance matters. So I look forward to having a fun discussion about those topics. Thank you.
Okay. Hi, my name is Sun Lee. I'm Eastern Europe in Korea. I'm from Kim and Chang. I joined Kim and Chang in 2010. I worked at a law firm in Hong Kong. So I'm a transactional lawyer, so for this panel I'll be providing more of a transactional view. But then when I joined Kim and Chang, it was around the time when Iran sanctions were very robust. And then I have been following up on the sanctions matter since then from the beginning for financial institution, and I think I'm much more, prevailing in terms of other non-financial institutions also being quite concerned about this issue. So I've been following up on this matter. So I've been in a kind of borderline between transaction and sanctions compliance.
Hi everyone, my name is Nicole Lee. I'm a senior associate at Gibson Dunn's Washington DC office. I primarily practice in the firm's white collar practice group, focused on corporate compliance matters, white collar investigations, both government facing and internal matters. And white collar investigations a few years back used to be very heavily focused on sort of traditional corporate criminal matters like FCPA, but increasingly we're seeing international trade come into play. And so I've been advising clients on international trade compliance programs. How do you keep up compliance when things are ever changing. So I look forward to talking about that. And I've also worked on investigation matters with a trade flavor, and so I'll try to bring an aspect from that perspective as well.
Great. So as Nicole mentioned, compliance program itself is hard to establish and maintain at companies because of the varying industries that they are in and all the unique characteristics that happen and the different business teams that you need to interact with. But it's especially harder for supply chain because of the changes that happen and also the complexities of the regulations. So I think I would like to hear how each of you view sort of the current landscape of international trade and supply chain compliance issues, and also how that affects the challenges that you see in establishing and maintaining the compliance programs. Why don't we start with Steve with the in-house perspective?
Okay, so I think in the last 5 years, lots of changes, especially in the export control. I think in the semiconductor industry, I think we don't really deal with those OFAC related sanction matters. Mostly it's export control. I think it's because U.S. and we call it allies and like-minded countries. They use the export control a lot in the semiconductor industry because the technological dominance is still maintained, controlled by the countries, like including U.S. and Korea, Taiwan, Netherlands. So, but if you look at the EV battery side, you don't really see lots of export control measures because the technology has been is spread. It's no one really controls the key technology. But in semiconductor, it's a little bit unique, and also. President Biden emphasized the importance of the industry many times. Sometimes raiding the wafers, things like that. But I think now semiconductor is a part of the national security, and so in that kind of complex surrounding, I think the companies, not just semiconductor manufacturing companies. Semiconductor equipment companies and material companies, all the companies in the same eco chain, I think they need to understand the export control accurately so that they don't face with any necessary entrepreneurship or criminal problems. So one thing I think I can emphasize from the company perspective is when I was in different I was in kind of, I was doing different legal issues, taking care of legal issues, but those times, as an in-house counsel, to analyze the legal risk, I think 99% is, all we need to do was, analyze the existing regulations and laws. But in export control, it's very different because you have to understand the trajectories of the regulation, even though you don't really see that the regulation or restriction maybe in a couple of years or in 3, 4, 5 years, you're gonna face with similar issues, and then eventually we're gonna see some implemented restrictions in that topic. So that's why extraterritorial applications of the antitrust law. I think many people or many experts talked about it, but extraterritorial applications of the export control, it was quite it's rarely discussed. But now it's a very big part of the export control. So that's my first point is maybe understanding the trajectory became a very key factor in the export control area. And also the export control means the export means something across the border, right? Either it's a physical item or technology or software. But one new trend is because the cloud computing, right? You can access high performance computers through the cloud system. So that means even without crossing the border, you can have all the benefits of the high technology systems. So that's why some countries are talking about how to control the use of the technology, not the actual actual export of the software and technology. So I think that's a new trend. It's just one example, but I think we're going to see more of those kind of trends in the export control area. So I think that's another thing that we need to pay attention. And I briefly mentioned that I did lots of anti-dumping matters and trade remedy cases. If I compare anti-trade remedy cases, I think those trade remedy cases was one of the key legal issues for the semiconductor companies 1990s and early 2000s. And that time, it's also very technically complicated and difficult to understand. But compared to anti-trade remedy procedures, I think export control is much more complicated and also hard to understand the details. I think the first reason that I can come up with is probably there's no international agreements in there, anti-dumping, subsidy, or even investment area. We have the WTO agreement. So many member countries have a similar skeleton, procedural skeleton. But in the export control, even there are some international treaties, Barcelona agreement, things like that. But they mostly control the items, but not the procedures. So each country has a different procedure. I think that makes compliance more difficult from the company's perspective, because we have to understand all the procedures of the countries that we are selling the product. So I think to improve the effectiveness of the compliance and also implementation, probably we have to more increase the commonality, not just the procedural commonality and substantive commonality in the export control. I think that's going to help not just the governments, not just the enforcement side. I think also the company side as well. And another perspective that I have is, and also compared to other legal topics, I think export control, I see very few opportunities to study or to improve the knowledge, because I think still in Korea, I don't think major law schools they offer export control courses. Even in the U.S., I think very few schools they have export control as a separate topic. Maybe it's part of the very broad sanction related subject. But I think now it's time to spend more resource in that topic as well. Okay, I'll stop there.
Nicole, would you like to?
Yeah, I'll pick up on that. So as a corporate compliance lawyer, this topic of supply chain compliance and international trade compliance is fascinating because it's so different from the traditional compliance that we talk about. When we talked about anti-corruption compliance, everyone knew that bribing people is bad. Bribing people is bad in Korea and in the US and in Africa. There may be different degrees of enforcement and how things play out, and the factual patterns might be different, but the overall sort of structure was the same. Same thing with, antitrust compliance, right? I'm not an antitrust lawyer, and I we at least have one practitioner in the room, but we understand, generally under antitrust regimes, competition is good. You're not supposed to collude. Price fixing is bad. There are general sort of principles that we understand, and ethics and other sort of regular compliance matters as well, right? Like you're not supposed to harass people. We all understand that. And those legal frameworks are not necessarily changing by the moment. The challenge here, as all of us know, is with international trade compliance, sanctions, export controls, and other sort of supply chain related compliance. It's really foreign policy dressed up as laws and regulations. And because of that, what you need to comply with is changing by the minute, depending on what is going on in the world, what the US government or other governments see as priorities. You might need to be mindful of additional sort of requirements. So that is one area that we as practitioners and we see in-house compliance professionals really sort of try to grapple with. And the trend, as you all are aware, appears to be that we are going to see more and more international trade controls. The US government is extremely active in coming up with new controls regimes and enforcing the existing ones. There are an ever increasing number of sanctions. And going back to export controls matters, as Steve mentioned, it's becoming more common to see sort of esoteric rules like foreign direct product rules, for example, be actually enforced, right? So the trends are expected to continue, and so that's one sort of heartburn that in-house compliance professionals sometimes have. And as, again, going back to what Steve said, this is, again, an area of law where what you need to comply with might be different depending on where you are. There are US sanctions and export controls that are applied extraterritorially, but with the rising tensions between US, Russia, and China, as some prime examples, we're seeing a lot of blocking statutes that are in place that are sometimes going to impose conflicting requirements on companies. And what do you do with them? Where do your risks lie? And so all of those things, and with that, at least from the US government, very, very active enforcement trend, make it a very challenging landscape for compliance professionals and lawyers in this regard. And so, we'll spend the next hour talking about what are some tips and tricks that we've seen in place as we advise clients in this area. But I agree, it's an area of law that we have relatively few professionals and experts in, and yet is becoming increasingly important and very intricately tied with the actual business operations.
Yeah, so if I may add, so in terms of, I think as a transactional lawyer as well as compliance lawyer, I think it is ever becoming more complicated in terms of dealing with, let's say it's a trade transaction or M&A transactions. Things to think about, whether, starting from knowing your counterparty, what are the kind of risks involved, what are the risks that are being dealt with, and also in terms of the execution and consummation of the relevant transaction. Maybe 10 years ago when we tried to do it, there are just a couple of boxes to check and then we are ready to go. Now there are at least dozens of things to check and just to make sure, whether in terms of strict technical compliance with law as well, but also at the same time, many of our clients are not only concerned about technical compliance with law, but their reputation and their risk management, which is many times, which is, if the technical compliance with law is at one level, risk management for different clients at another level, and then we need to think about how high a bar do we need to set in terms of thinking about proceeding with a transaction. And this is rather a difficult issue, and then I think it's ever becoming more difficult because I think when we talk about like Cuba, maybe 60 years ago, or Iran, like 10, 20 years ago, and even today, but the answer is somewhat easy. So you just don't do anything with those countries. But now, if you're talking about China, if you're talking about Russia, if you're talking about CIS region and some of the STAT countries, or even like if you talk about Dubai, if you're doing a transaction and in a company in Dubai, are you really risk free? Even though Dubai, yes, I shouldn't pick a specific country, but because it typically kind of comes up, Dubai or CIS countries, because they often becomes a venue in terms of, I shouldn't use the word circumvention, but just doing transaction more in an efficient manner. If that kind of issue comes up, what are the things that we need to check? And that there is practical, of course, there are theoretical needs and ideal objective that we would like to achieve, where basically making the risk zero. But that's, of course, in practice, not possible, because many times when we do a transaction, it is very, very difficult to use the ultimate end users, for example. And how are you going to actually for example, if you're dealing with a distributor, how far are you going to get in terms of pushing your distributor to disclose your end users? Yes, that's in a practical, theoretical sense, we should push hard, but practically, that's very difficult. So I think that's the lines that we need to kind of think about, and often that's where the issue comes up. And yes, at one juncture, we're a law firm, we need to advise them what are the risks and what are the risk mitigation measure, whether it be documentation or due diligence and so forth. At one point, the client needs to make an informed decision. So I think it is we are at many times need to think about what the clients are thinking, but this becomes ever more difficult issue. So whether try to resolve that from a kind of case-by-case basis or more systemic basis, I think this is something that we're getting into a world where it should be better for law firms because there's more to work, but at least for doing transactions, it's definitely becoming more difficult.
Yeah, those are all really great points, and the fact that all of you had many different things to say about this one question of what challenges exist it can be discouraging if you're an in-house professional trying to build a compliance program, but we'll try to turn this into a positive conversation. So let's sort of go into like what practical steps you could take and start with how to keep up with all of these changes in the first place. So I think we'll start with Nicole, since you have advice on compliance programs and agents.
Yes, so one of the key challenges actually in this area of compliance, as I mentioned earlier, is sometimes you have to figuring out what you need to comply with is a very large step. There are new sort of developments coming out, and so how do you keep up? And there are a lot of different companies have different strategies. Just to kind of float some very easy, low-hanging fruit. One way I practice in the DC area, a lot of international trade lawyers, including some of us in the room, are practicing in the DC area. We're frankly one of the first people to issue client alerts and summaries and try to figure out when there's a new regulation coming out or if there's a proposed rule, trying to assess what is that going to mean for certain industries or certain types of clients. So, the lowest hanging fruit perhaps is just, you might not want to subscribe to all of the law firm listservs, but there may be a few that you want to consider subscribing to just so you can get sort of close to real-time updates. And speaking of listservs, there are other ones that are directly from the US government. Obviously, those are not going to come with, the analysis and the summaries. But for example, OFAC has sort of recent actions updates, other when other regulators will have similar listservs. And then you may also want to, there are particular sets of regulation that's coming down the pipe, and there's going to be a final rule that's going to be proposed, you might want to, sort of subscribe to those listservs to stay on top. There are some international trade conferences with thought leaders attending. I won't, name specific ones, but I do know, for example, there are annual conferences in the DC area where a number of the US regulators typically attend. So you might want to consider, what are the key sort of conferences and publications you want to subscribe to stay on top of the development.
Senor, do you have anything to?
Sure. Maybe I know we are in an ABA conference, so maybe giving a slightly different perspective. In Korea, so I've been working in Korea for maybe a little over 10 years now. Finding a relevant statutory provisions are quite simple because the so-called there is a Ministry of Legislation that keeps track of all the relevant laws and all the laws and regulations, including the guidelines. They put that onto a website, and then they update it on a very regular, real-time basis, as much as in Korea it's called National Assembly, the Congress equivalent. As soon as the law is enacted, they update the system. So you don't have to use like less equivalent or the like to kind of surf around. On the other hand, U.S. law in general is very, very difficult, not only for U.S. citizens, but also even more so for foreigners, foreign companies looking into the U.S. law, trying to understand. By the way, there is a federal law and the state law by each state, and for financial institution, it's more focused on New York law. You just need to, what happens in Manhattan is important. But on the other hand, if you're talking about non-financial institution, you have to look at 50 states or at least those states that you have businesses in. So it becomes very, very complicated. So yes, we need to use U.S. law firms. We need to work with them as a law firm, as a South Korean or other foreign law firms looking into U.S. law. I think more so for this export control and sanctions area because I think in the previous session we actually talked about what the role of FAQ is. For example, OFAC issuing FAQ, and then what we many times see is when we work with a U.S. law firm, we talk about what is the view on this particular executive order or whatever, and then many times there is no kind of statutory basis other than the statutory language, and then there is this FAQ from OFAC or BIS saying that this is what this means, but then there's a disclaimer saying that this can change. So I don't know exactly what that means, but anyway, the reason being that in this particular area that there's not that much of a precedent because in many cases, to my understanding, maybe 90% or so, other than those brave companies who are willing to stand against the U.S. government in terms of challenging whatever that may be, in terms of export control or economic sanction, they typically settle, so that there's no kind of interpretation of law or regulation. So I think this becomes very, very complicated issue for especially foreign companies trying to understand, and there are two angles, right? So one is in terms of understand and try to comply with the law, and the other angle is more preventive and trying to set up a system in a systemic manner so that they can continue to comply with the relevant laws and regulations. So that is actually the reason why we need the foreign companies, as Korean companies, for example, they need regular updates and discussion with the law firm, the U.S. law firms in terms of being updated and trying to, and on a real-time basis, trying to comply with the law. And I see, for example, I think for sanctions lists, SDM lists, they're updated and there's no grace period involved. So typically, you need to, for financial institution or non-financial institution, at a get-go, you need to just comply with it. And there's a transaction that you could do yesterday that may not be true today. So that's something, that's how kind of, how real-time basis that you need to to comply with. So that's something that we need co-work as a foreign law firm with the U.S. law firm in the context.
Okay, again, from the kind of company perspective, I think maybe last decade, lots of like it used to be to the in-house counsel, they have like they have their own like expertise like antitrust or something like trade remedy or I mean it depends what kind of industry you were in, but I think semiconductor industry dealt with like several major legal issues. But these days, I think they affect each other a lot. So I think it's hard to stay in one segment of the law. So because national security applies to export control and investment decisions and merger approvals. So I think one trend that the companies are, especially like companies doing business internationally, like us, we export more than 90% of our products, overseas. So means the in-house team, they need to understand not just their own specialties, the other risks as well. So and also, these days those sanctions and then understanding and analyzing those export control and sanctions properly, I think we need to understand the industry very accurately as well. Just understanding legal aspect of the sanction, you can reach at certain level, but you cannot really get the final answer because in the company most questions from the business segments is can I do this or can I do that? Can I sell this to this place? We cannot say it's legally okay to sell that, but it's the risk is yours. I mean it's not something internal. In-house counsel can talk to our internal people. So we have to come up with. So of course we work with lots of good law firms in the U.S. But frankly ultimate decision making should be done by the in-house people like management and the in-house counsel. I think to do that, I think the deep understanding about the industries is critical. So means I think internally companies need to spend more resource to improve the capabilities of in-house counsel, not just in the legal side, but also in the industry as well. So that's why I think I sometimes make a recommendation to the management that I think when we send people to for some like technological training programs, I always recommend we need to send some lawyers to there so that they understand the products, technology, then they can come up with more accurate analysis of those export control questions. So that's one thing. Yeah, I think I stopped there.
Yeah, those are all very helpful tips and tools. I think it would also be helpful to hear more about sort of the real life examples that you've had to sort of kickstart the conversation. The industry that I've seen the most change in the recent past is, with the recent Russia sanctions that are especially targeting the biochemical weapon capabilities. We have seen an increase in a lot of questions from the healthcare and the medical industry. Those usually were able to benefit from the numerous exemptions and general licenses that are issued by the government, but the recent Russia sanctions have sort of caused a lot of headache for them, and we have helped a lot of them try to sort of navigate what the new rules mean, how can they take advantage of the narrower set of general licenses, can they seek specific licenses, if they do, what do they need to provide to the government to give them comfort, and it really comes down to, as Steve said, understanding your product, understanding your end users, understanding the product flows of how they get to the ultimate end user, and being able to explain that to the government. So that has been really a challenge that has come up in the recent year, I think, that we've sort of helped the companies walk through. So some of additional examples of other industries that you've experienced, I think, would be very helpful. And I think we know what industry Steve is going to talk about, so we'll start with Steve.
Okay, so I mean, we don't deal with Russia and those countries, so I don't think we have any experience to share with about those countries. But I think overall, instead of picking specific countries or companies, but I think in that topic, I think maybe burden proof is one kind of interesting topic we can talk about, because BIS has a policy called know your customers, right? So I think to me basically it's kind of shifting the burden of proof to the sellers. So of course to comply with those sanctions, regulations, and export control guidelines, I think we companies need to do our best to be in compliance with those various kind of restrictions and rules, things like that. But the question is how far we have to go, right? So because not just semiconductor, most I think consumer products or go through many different levels of transactions, and then eventually a product reach to a kind of a customer who is on the certain entity list, and who's going to be responsible for that kind of transactions. So I think one concern from the industry, one possible potential concern is I think they have to draw the line very reasonably. If not, if the enforcement governments put too much burden on the company side, the seller side, in terms of investigating and figuring out those tracking down those destinations, I think it's going to be very practical difficulties for the companies. And I think the other one that I would like to mention is like saying going back to the lack of commonality in the procedural and substantive aspect of the export control. I think that's a big challenge for us, because we have to understand those system by each jurisdiction. So that's another challenge.
Just to kind of build off of what Steve said, the panel just before ours talked about what's happening to free trade, and one of the things that one of the panelists mentioned is, some of these trade controls is really not designed to control the behaviors of the companies that are complying, right? Like the Uyghur Forced Labor Prevention Act is not designed to control the behaviors of external parties more indirectly, and so there comes the challenge. And again, drawing a comparison to the more traditional anti-corruption or antitrust or other compliance programs, those things are designed to control your own behavior. Your company employees are not supposed to bribe people or engage in price fixing. But here we're now having to figure out who's my distributor selling to, and where is my supplier sourcing their materials from, and really kind of reaching beyond what we are able to control more directly. And so we'll talk about the more sort of specific compliance strategies, but that's a very big challenge. I know there's a recent resolution involving 3M, as I'm sure some of you are familiar with, and 3M ended up paying about north of $9 million in civil penalties. And that was also because 3M had sold goods to a German party who then ended up selling it to a government entity in Iran, right? And there was a little bit of a process fallout in the internal processes. And so how are we able to detect all of those things, are business people really equipped enough to spot those issues, right, when they come up? Because this is not what this is not necessarily intuitive for the business folks to be like, okay, I gotta now figure out what my customers, who my customers are selling to, how would I know that, right? So those are, I think, some of the practical challenges that we're seeing that our clients deal with. And, good or bad, it seems to be here to stay. To cast a slightly, I don't know how positive this is, but one positive spin I'm going to try to put on is I do think that that the supply chain compliance and trying to, the companies trying to understand where the products come from upstream and where they're going downstream is ultimately going to kind of have synergies with the whole drive towards ESG. A lot of companies are focused on ESG and sustainability, and a big part of that is going to have to deal with where your supplies are coming from and where your products are ultimately ending up at. And so, it is a lot of work, but it will probably have sort of, multiple sort of channels where the types of information you're gathering is going to be used in sort of different aspects.
So if I may build up on that, just in terms of examples, maybe dealing with Russian oil or Iranian oil, I think that's a simpler story, and I think but maybe not too simple, but at least it's a more something that is more visible. On the other hand, there are many instances that we're dealing with that are more subtle. For example, cotton from Xinjiang area, or silicon, which is becomes a base material for a solar panel. Whether that's to the extent that they're from Xinjiang, it could become an issue. Now, as a foreign company trying to find the original source of where this is coming from, whether it be a cotton or silicon or whatnot, and ultimately trying to find out whether was this really from Xinjiang or was this from the village next door that does not have an issue, or maybe it's not that subtle, but that is a difficult issue. Not only in terms of trying to find out, because there could be many chains of supply chain that are involved in that type of trying to get the raw materials or whatever the materials they needed for the final products. And also, China could be one example that is more challenging, where they have their own type of security laws and regulations that have been placed, where it is quite difficult for to go around and asking questions, and which could be violation of law. Maybe not in Korea, but yeah, there are other regions where it could be more risky for companies to do that. So in that type of scenario, I think I think the companies are experiencing how to deal with, and to what extent they can actually satisfy relevant laws and regulations in terms of trying to not violate laws, but there are practical limitations. And another example from the sanctions side is maybe Russia, because I think for Russia, as some of you may know, it's not a comprehensive sanction. So you can actually do transactions to the extent that you can actually structure it as long as you're not dealing with sanctioned party. But then SDN has a so-called 50% rule, where it's indirect or directly. If SDN holds 50%, then all the relevant parties downstream becomes an SCN, whether OPEX or not. So in that kind of context, if you're dealing with a Russian party, how deep can you go in terms of trying to find out whether a particular party is a SDN party or not in terms of this 50% rule? Yes, there's this great database, Thomson Reuters or whatnot, that provides this type of information, but they can't go so far. And also, As with the U.S., Russia and other regions are quite opaque in terms of what they disclose in terms of their corporate governance. So in that, with that being said, and how, in terms of KYC or other due diligence measures that can be implemented, one way may be documentation, so saying that, give us relevant ransomware, give us indemnity, give us covenant, give relevant comfort. But then, when you're dealing with, for example, as a foreign company, dealing with a Russian entity, for example, they are very, very sensitive in terms of referring to any sanctions. So sometimes we may end up with a term of so-called, for example, legal restriction, whatever that may mean, with no reference to sanction, and at the end of the day, it becomes a dispute whether that actually should include U.S. sanctions or not. That becomes an issue, and also whether to include that kind of same provision in a force majeure provision, that also becomes quite tricky. So these are things that, at least in terms of Russian sanctions, we have been dealing with since last year, maybe even so from like 2014 when the Crimea issue it became a problem for parties that are dealing with Russia. But I think, but China is more difficult. I think that because at least from Korean perspective, yes, there are this trade tension between U.S. and China. And I think Korea is in a is a country where they have to play a very fine walk a very fine line in terms of militarily they need to be very close and economically as well, very close to U.S. for historical reasons and other reasons. But in terms of proximity, they're so close to China. And then U.S. and China are both number 1 and 2 trade partners. So they cannot really get rid of China. So how to deal with this type of issue from a trade compliance and supply chain issue, it becomes very, very, was it too dark? Sorry. Yeah, but there's something where when law firms come in and try to rectify the situation. Thank you.
The last sentence was enough of a positive spin for her. That's okay. But sort of the general trend that I'm sort of hearing is you need to gather information, assess the risk, and make sure that you have everything you need to, both prevent that there is nothing bad happening, but also be able to explain whenever bad things happen. And so I think that's a, good way to move on to sort of the general strategies. And I think there could be both a sort of a defensive strategy in terms of compliance. Whenever things happen, you can take an action, and also an offensive compliance strategy where you try to proactively do something. You can engage the government before something happens. And so let's talk about the different kinds of strategies and maybe start with the defensive strategy first. So Sven, do you have anything?
Sure. So I mentioned about this ideal world where from a corporate perspective, they're complying with all the laws and regulations, and they're risk zero. Unfortunately, that's not reality. Both in terms of sanctions compliance, supply chain compliance, AML compliance, it is a risk base. So each company has their own risk set of risks, and it's something that they need to mitigate. But at the same time, when we actually talk to clients, maybe they're this low, maybe from the Korean side, maybe the US side is a bit more adapt to that type of thinking, but they're quite reluctant in terms of accessing their risk. I think it's not, maybe financial institutions are more so, they're very adaptive to what is going on, just because the financial systems are all connected, and U.S. financial system has been quite predominant, and for South Korean financial, maybe just sidestepping. Korean financial system is, even though it's not a tagged system, they are quite interconnected with the U.S. financial system in a sense that there is, for foreign exchange market, predominantly is a Korean won to U.S. dollar. Then that would mean that even if you are, for example, remitting a euro by converting from Korean won, there is no official stance Korean won to euro market. So that then rather you need to go through U.S. financial system in order to, for example, remit euros. So that is the reason why the the Korean financial institutions even are very wary and then try to comply strictly with the U.S. Sanctions and all the other regulations. From non-financial general corporate perspective, they have been much slower in terms of trying to understand why U.S. Compliance issue becomes actually their issue, even though they're very far away. And then trying to let them understand and many times where we end up is that, everyone talks about the sanctions compliance, everyone talks about this trade compliance, that set up a system, they end up just promulgating internal regulation without really understanding their risk. On the other hand, what we recommend is that you need to, because it cannot be ideal, you cannot prevent everything. So you need to set up a system where there are two objectives. So one is so that accidents do not happen, so that you don't actually buy accidentally even, or we shouldn't assume intentional misconduct. So at the minimum, in a negligent manner, you're not violating any law. So that's one thing. Second is that even in case where you actually violate the law, there is a mitigating factor for you. So you have all the systems, so it's not a system failure. You have something to say to BIS or OFAC saying that this is something happened accidentally. So in trying to reach those two objectives, you need to have a kind of a system, and that's where we are trying to push for example, Korean companies to adapt. I think this becomes more. I think it's becoming more challenging. I think I'm going back to the point where if you're talking about Cuba or if you're talking about Iran, it's more simple. North Korea, South Korea does have this separate sanctions regime and trade compliance, trade regulations on North Korea, but for Iran and maybe it's more easier. But then China and then Russia, I think that type of risk assessment is definitely needed, and coming up with an internal system that actually that addresses this type of very subtle issues is very important. So that's how we typically approach this type of defensive measure.
I echo a lot of what Sun said, and obviously going back to the risk point, you're risk-free if you don't do anything. But businesses are not meant to do nothing. So you've got to understand what your risks are, and frankly, that's what a lot of the U.S. regulators' guidance and compliance programs are too. The hallmark of an effective compliance program is that it's risk-based and it's tailored to the risks of your own company, your own industry. And so, I won't go into the details of the elements of an effective compliance programs. A lot of different regulators in the U.S., including DOJ and BIS and OFAC, all have guidances on what they consider to be essential elements of an effective compliance program. I do think, especially in this particular compliance regime, it's really important to partner with the business. And so oftentimes within certain companies, compliance is viewed as, they're the ones, these are the naysayers, these are the people that tell me I can't do things, right? These are the people that say no and I can't pursue a particular business lead. And in this area, I think there's a real opportunity to partner with business, because exactly like what Sun said, with trade controls, sometimes you can structure things so that you are compliant. Obviously you can't structure briberies so that you are compliant. But this is an area where, depending on how certain things are structured, you could be. And so it's really important to have the business see you as, we are here to help you identify what your risks are and help you plan around it. And how do we do that, right? So, messaging is going to be critical, training so that the business folks understand when to raise a red flag, when to ask questions is going to be critical. These are critical generally in the compliance world, but especially in this scenario because again, these are not going to be intuitive things that business people are going to be able to flag unless they're very well trained. So I will just flag those. One anecdote I wanted to quickly share is with all of the compliance measures you have internally, it's also really critically important to document things and pre-plan. So recently I had a sanctions investigation for a European client who, there was an allegation that their subsidiary in Syria had violated EU sanctions, and so they were doing an internal investigation. And it turns out they were compliant, but because there was not such great documentation, it took a long time and a lot of document review, a lot of witness interviews to backtrack and reverse engineer what exactly is it that they did to comply, right? And when you have a regulator coming to, knocking on your door to say, did you violate X, Y, and Z trade controls, it will save you so much time and money and legal fees to be able to quickly go back and say, hey, these are the things that we did, here's the force majeure clause that we exercised on this date, and this is the communication internally. Like, very, very easy steps to take that is going to save you a lot of headache down the road. And also, in this case, one of the things that I learned for my client is that they actually did a lot of pre-planning. So even before the sanction became effective, they were trying to evaluate, okay, do we need to exit from this market? And who are our major customers? What does our force majeure clause with this client say? When can we exercise it? And so they actually were able to implement a lot of steps on day one, which can be really important. So, I mean, sometimes you can't predict all of these steps in advance, but there are situations where something is coming down the pipe and you are able to take certain measures to be able to implement on day one. So those two are the things that I would just highlight on top of all of the regular good best practices in the compliance world.
Okay, again, from the company perspective, I think this is compliance is compliance. We're working with capable lawyers, and then not just us, the global companies have been maintaining very robust internal compliance program for a long time, actually many years. Not just in those trade related export control, also include the antitrust compliance programs. So, but I think bigger challenge for the people inside. It doesn't have to be a lawyer, but people in house and who is dealing with export compliance. I think the bigger challenge or responsibility is to minimize the potential compliance. The situations where the company put the company into those compliance situations. So it means going back to another the trajectory kind of related arguments is because we need to. So that's why I'm based in DC, but DC we're trying to understand the thought process of the major influencers in DC. Then we can kind of come up with maybe that area we need to pay more attention to that area. Probably they're going to come up with some sort of either guidelines or regulations, things like that. So I think providing I think Nicole mentioned pre-planning. I think it's kind of pretty much related. We're trying to foresee the areas of the sensitive areas that not just the U.S. government, the areas, countries that we are dealing with, they might come up with some sort of new measures. I think that provides very valuable knowledge and information to the decision makers. So I think from company perspective, compliance is also very important, but that's a little more like technical procedure for the companies. But I think the forecasting or pre-planning of those potential areas of compliance, I think it's more challenging and more valuable to the company.
That actually flows really nicely into the offensive compliance strategy. The DC influencers are definitely very important in devising compliance strategies. So Nicole, since you're also based in DC, what are some of the affirmative compliance strategies that you can take?
Yes, so again, this is one area where it's a little bit different for international trade compliance versus the traditional sort of anti-corruption or antitrust or other more traditional areas of compliance. Because again, this is an area where you could be more affirmative or offensive in your compliance strategy. And especially for companies based in Korea, we're really seeing an area of opportunity. You know, a lot of the international trade controls these days are targeted sort of against certain economies in the world, right? Russia's and China's. One of the key sort of strategic point of the Biden national security strategy was that the U.S. should be outcompeting China. So, you know, in order for the U.S. to do that, they're going to have to partner with certain allies and friendly powers, and South Korea with all the technological advancement and where the country is diplomatic with the U.S. is going to really be in a strategic space, we think, in a lot of situations. We do think that the exemption that the Korean chip makers were able to get, you know, along with other friendly chip makers, is a demonstration of that there will be certain areas of opportunities for companies in Korea. And so to take advantage of that, one thing that companies can explore is seeking specific licenses for certain transactions. Again, you can transact around certain trade controls or seek exemptions, right? So you should work with the right folks who know how to advocate for you, how to make your case in front of the U.S. regulators. But there are certain specific licenses you may be able to obtain. And then on another side of the offensive strategy is obviously lobbying, which can kind of depend because in the U.S., you know, government advocacy, government relations, lobbying, you know, those things are legal, right? And in certain countries, they are not. There are areas that you should be mindful of when you are considering you know, engaging directly with the U.S. government, for example. If you're a foreign country, your agent needs to be registered, etc. But you know, there are sort of certain direct advocacy you might want to consider. And just on that point, you know, there are different considerations when you're engaging directly with the U.S. government. You might want to do it on your own as a company or as part of a trade association. There may be different strategy considerations. Obviously, when you're in a trade association with other competitors, that you might not be able to advance all of your own sort of strategic goals, but you may have a bigger voice as a group. So there are things that you can think of, and there are partners, I think largely based in DC, who are able to kind of strategize with you on that. So that's something that, you know, I think a lot, especially in the trade compliance and supply chain compliance area, you should consider in connection with kind of the traditional having a good program.
Yeah, Sunya, I think your perspective will be very helpful in terms of, you know, doing that offensive strategy outside of the United States.
So first, in this part of the world, lobbying has somewhat of a negative connotation. So we typically use so-called GR, government relations, just FYI. Yeah, so I think from Korean companies' perspective, they do try to seek be more offensive, even though many times it is more kind of defensive story, I have to say. But one particular area that I just wanted to kind of bring to attention is the FAR, where Korean companies or foreign companies are utilizing a agent, including law firm, to lobby or otherwise contact U.S. regulators other than maybe interpretation of technical interpretation of law or otherwise. So in that kind of context, how we thought about it, and then from a foreign company's perspective, I don't think there's any other jurisdiction there is so much information is disclosed in terms of FARA disclosure. That often becomes an issue, and I think how foreign companies deals with that particular disclosure matter is different from company to company, and depending on how they're comfortable with that kind of regime. But often, Korean companies are, I mean, depending on the company, it's a case by case basis, but many times they